The second case is 22-50828, and it's James versus Hegar. Ms. Baumgardner, did I pronounce that correctly? Are you ready to proceed?
Thank you, Judge Douglas, and may it please the court. The easiest way to dispose of this appeal is on the sovereign immunity grounds, so I'm going to devote my argument time today to talking about that. There are a couple of sovereign immunity theories that are floating around in the briefing, as your honors are aware. One, of course, is Ex parte Young, and I'll talk about that one first. The second one is what the plaintiffs present as an alternative way, an alternative to Ex parte Young, that is to get around the controller's sovereign immunity. They call that the Lee Malone exception. I'll talk about that second. In terms of Ex parte Young, the plaintiffs haven't pleaded any facts tending to show that this alleged violation of federal law is ongoing or certainly impending. Now, they say in their brief to this court that their allegations regarding the 2020-2021 budget are just an example of the kind of conduct that they allege is ongoing. But as the Supreme Court said in City of Los Angeles versus Lyons in 1983, alleging that the plaintiff has been a victim of purportedly illegal conduct in the past says nothing about whether the plaintiff will be subject to similarly allegedly illegal conduct in the future. Moreover, the Supreme Court in Lyons made clear that as applied to this case, generally alleging that the controller generally does this kind of thing is not enough to qualify the plaintiffs for prospective relief in a federal court. In Lyons, of course, the plaintiff alleged that the LA police officers were applying chokeholds where those weren't warranted, but the Supreme Court said that kind of general allegation just doesn't cut it when it comes to seeking injunctive relief in a federal court. The court said that in that case, Mr. Lyons would have had to allege not only that he would have another encounter with the police, but also that the officers did this every single time, or that the city had ordered or authorized them to do it every single time. And without those kinds of allegations, the Supreme Court said he had not qualified for prospective relief from a federal court. The plaintiff's allegations in this case suffer from the same defects. In this situation, translating what the Supreme Court said in Lyons to this case, the plaintiffs would need to allege not only that perhaps, as an example, that they had funds in other accounts that they thought that the holders, their banks, might turn over to the controller, but also that the banks did this every single time, or that the controller had ordered or authorized them to do that every single time. They haven't made and likely can't make those kinds of allegations, so under Ex parte Young, they're not entitled to prospective relief. Now, I'll turn now to this Lee Malone exception the plaintiffs talk about in their briefing, and as far as I can tell, that exception goes something like this. Number one, the plaintiffs have alleged that the controller has possession of money that doesn't belong to the state, but that instead belongs to the plaintiffs. Number two, the plaintiffs have alleged that he obtained possession of those funds via constitutionally infirm action. Ergo, per the plaintiffs, they should be able to circumvent the controller's sovereign immunity in order to ask for the funds back. There are a couple of problems with this theory. One is more of a practical problem, the other one is more of a legal problem. The practical problem is that the district court has already dismissed all the plaintiffs' official capacity claims to the extent they seek a payout from the General Revenue Fund. That's in the record at pages 442 and 448. So, and because of the interlocutory appeal posture of this case, the plaintiffs haven't appealed that conclusion. So that conclusion by the district court has to stay where it is. So those claims that seek a payout from the General Revenue Fund are dead. But those are the claims that the plaintiffs are trying to use to get around the controller's sovereign immunity via the Lee Malone exception. But it doesn't really make sense for them to be able to use claims that are dead to circumvent the controller's sovereign immunity. So that's the practical problem. The legal problem is that the cases they've cited don't allow them to circumvent the controller's sovereign immunity to ask for money back from the state. Obviously, this is the Edelman versus Jordan problem, where the Supreme Court said that you can't get around the state's immunity to seek a payout from state coffers. There's obviously that ancillary relief thing where if it's ancillary relief, then, or if it's ancillary to the court's judgment or prospective relief, then you can. But that's not what this kind of case is. Now, all the cases the plaintiffs have cited for this exception, United States versus Lee, Malone versus Baudouin, and Florida Department of State versus Treasure Salvors, all involve non-fungible, tangible property. Lee and Malone both talk about land, and the Treasure Salvors case is obviously the case about the remains of the ship that were at the bottom of the ocean. In Fontenot versus McCraw from 2015, some other plaintiffs tried to use those cases, particularly Treasure Salvors, to get around the immunity of the director of Texas's Department of Public Safety. The plaintiffs in that case were seeking also a payout from the state coffers because they believed they had wrongly paid money, they had been overcharged. And this court said that Treasure Salvors, and by extension, Lee and Malone, didn't get them around the DPS director's immunity because, as this court put it, suing the state for the return of physical, non-fungible, tangible property is just fundamentally different from suing the state for the return of fungible, non-tangible dollars. And that's what the plaintiffs are asking for here. Now, of course, we recognize that the plaintiff's basic theory seems to be a version of the money doesn't belong to you, controller of the state of Texas, so we should be able to sue you to get it back. But they haven't cited any authority to this court that would allow them to get around the controller's sovereign immunity to ask for money out of the state coffers in this circumstance here, because Lee, Malone, and Treasure Salvors just aren't about asking the state for a return of funds. I'd also like to address an allegation in the plaintiff's complaint in the record at page 15. They allege that that unclaimed funds that are reported and delivered to the controller under the Unclaimed Property Act are placed in a sort of sub-fund within the General Revenue Fund. The plaintiffs call that the Unclaimed Property Security Trust Account. This allegation doesn't help them for a couple of reasons. The first reason is in the name of the account, the Unclaimed Property Securities Trust Account. The property that the plaintiffs allege that the state has that belongs to them is not securities, it's cash. So this fund, even if it were availing in other ways, wouldn't help them because it wouldn't hold the kinds of property or the kinds of unclaimed property that the plaintiffs had, that this case is about. The other reason that allegation isn't helpful to them is because that fund is defunct, effectively. It's a holdover from a past version of the Unclaimed Property Act and before the legislature had required all unclaimed funds to be deposited directly into the General Revenue Fund under Property Code Section 74.601. Now, obviously, since 1996, the legislature has required that, and so all unclaimed funds are poured directly into the General Revenue Fund, which is effectively the state's giant piggy bank. That fund, the one that the plaintiff's allegations are about in the record at page 15, does still exist, but it's defunct, and there's been no activity on it since the year 2000. So as a matter of state law, that allegation in the record at page 15 in their complaint is unavailing. I think that's all I have for this time, unless the court has any questions. For now, we'll ask the court to reverse the district court to the extent it denied the controller's motion to dismiss. Thank you.
Thank you. Mr. Paul?
Thank you, Your Honors. May it please the court. Good afternoon. I guess since the appellant started with the sovereign immunity question, I'll start there as well. The issue in this case, and I think why the district court below got this question right, is that the facts here are very different from those in the city of Los Angeles versus Lyons, the Specs family partnership case, the Adams case from this court. All of those cases involve past conduct that's done and over with. And so if we look at the Lyons case, Mr. Lyons was put in a chokehold, but he was no longer in a chokehold. And he didn't have a basis to say, I'm going to be in a chokehold in the future, because he'd have to say, I plan to engage in criminal conduct. That was the court's finding in that case. Here, My clients had their property taken. It is still taken. And so the analogy between the two cases is my clients are still in the chokehold. It's not over. Their property has not been returned. They are still suffering from an ongoing takings. And that was the finding that the district court made based on the pleadings, is that there was an ongoing violation of the law alleged in our complaint. And under this court's jurisprudence, when you have an ongoing violation, you get to move forward. Now, let me deal with the federalism concern. I wholly agree that asking a federal court to adjudicate a state's interest in property is out of bounds, off limits, can't do it. I think our jurisprudence is abundantly clear on that. This case is different because the state repeatedly, over and over again, in their pleadings below and in their pleadings to this court, have acknowledged it's not their property. We are not asking a court to adjudicate the state of Texas's interest in any property. It is all property belonging to the citizens of the state of Texas. So there are no federalism concerns being implicated in adjudicating that interest. I also want to go the next step. So I think that in terms of decision, my opposing counsel started with the easiest way to reverse. The easiest way to affirm is to affirm the finding that the district court made. There is an ongoing violation alleged in the complaint, and that satisfies the ex parte Young provision to seek prospective relief. And to be clear, as was argued previously, the district court here cut off all other forms of relief. Under the order that exists today, he's only allowed declaratory or injunctive relief prospectively to be sought. And so he's narrowed the case to what ex parte Young specifically allows. And he found that the factors of each of the elements of the ex parte Young exception to sovereign immunity have been met that allow the 1983 claim to move forward to seek that prospective relief. Because of the argument that I've just made with respect to federalism, we have offered the Lee Malone exception. I don't think you need to get there because I think this is an easy case on there's an ongoing violation. But with respect to Lee Malone, it's true that that's out of the case right now based on the district court's order. My position would be the state has put that in issue by arguing, because it is an alternative basis for this court to affirm the district court's position below on sovereign immunity and the application of ex parte Young based on a question of law. So I think they've inserted it into the case, and therefore this court can decide that when you're not seeking property or not asking the court to adjudicate an interest in state property, we don't really have the same concerns that have been placed at issue in other courts. And I would note that there was significant briefing on this court's Arnett decision, but the interest was state property, to be clear. And that is why we made that distinction on those cases. No question, the unclaimed property law of the state of Texas allows them to take the interest. So when they put that in the state coffers, it's state property. No question about it, and asking for the return of that is damages. But in this case, we're not seeking the interest. We filed it asking for the return of our property. And so for that reason, I think they have placed the Lee Malone exception back into the mix here. But to be clear, it's only an alternative basis, because I think that the issue for this court to decide is, did the district court get it right in finding that we alleged an ongoing violation? And that is sufficient to invoke ex parte Young.
Tell me what the background here is, because I don't know whether I really have a good grip on that. The state this money was unclaimed, well, it wasn't unclaimed, it was in somebody's name, okay?
Correct.
In a bank account, right?
That is one of the pieces of property at issue, correct?
Okay, so, and it was there for X number of years,
It was.
no action.
No, actually, we dispute that, and that is part of the case as well. They claim, and that is part of what we say they're doing wrong here, is they say, well, it's abandoned property. This wasn't abandoned property. This was a retirement account that was being actively traded, and all of a sudden was given to the state. We have no explanation for that. That's our allegation. That's what the facts that we understand to be true are. Again, we're here on the pleading stage. We've not gotten into discovery to explain why in the world the state took property that was not, in fact, abandoned and treated it as such. We don't have an answer to that. But we dispute. They said that they gave it to the state.
And did they say anything about, and it isn't just this particular customer, it's potentially others?
They didn't say that, but we have information to that, and that was the basis for our allegation that this part of their reporting system, which we can see in the website that they have, is they allow financial institutions to produce money to the state in their own name rather than in the name of the person who held the account. And then on occasion, and we don't know how prevalent this is, but we believe it's widespread, that the state then gives it back to the financial institution and they pocket that money. I don't understand the incentive behind it. Maybe there's a split of the money. I don't know what's going on, but it's bizarre. And that's part of our basis. All of this comes back to, we've been focusing because of the nature of these issues on the takings aspect of this. But the due process solves all of it. If the state would exercise procedural due process here, this would be a non-issue. We talk about.
What kind of notice does the state give?
They don't. Well, let me divide it into two. Pre-deprivation notice, they don't give any. They order.
Give it to the bank.
They order the bank to give notice. But I think the Supreme Court has been clear that the state may not delegate its constitutional duties. The state has to give the notice. So that doesn't count as due process notice. We also have alleged that the holder did not give notice, but I think that's immaterial for the due process question. So for pre-deprivation notice, there is no notice. Post-deprivation notice, our argument is that the Mullane standard for notice applies. Notice it's designed to reach somebody, and instead they post it on a website. Part of our allegation there is they know who these people are and they know how to return it. And one of the examples in our complaint is they hold in custody several pieces of property from Governor Abbott. They know who Governor Abbott is. They know where he's at. They know how to return the money. They're not making any effort whatsoever to return unclaimed property to the people, which is the entire mission of the unclaimed property law. So I do want to be clear about that, because in the briefing, there's this suggestion that we're making this broadside attack on the notion of unclaimed property laws, and nothing could be further from the truth. We want unclaimed property laws. My clients want there to be something that functions, but from their position, if there was due process, their property would never have been taken, because their name was always connected to this property, and both the holders and the state knew who they were and knew how to find them. They are tax-paying citizens, they have residences, they haven't moved, they're not difficult to find. If the state made the slightest effort to find my clients, they would have found them. But they didn't make any, other than this website, which they say is notice. It may be a form of notice, but I don't believe it's a notice that would satisfy the Mullane test.
What's the bank's responsibility?
The bank is under the threat of criminal penalties if they don't turn property over.
Yeah, but is there any procedure at the bank to notify the holder of the account?
The Texas unclaimed property law imposes a duty on the holder to give notice to their customer prior to turning the property over to the state.
Right, and they did that here, as I
They did not do that. That's part of our problem.
So the obligation is on the bank.
There is a statutory obligation.
Well, you got another defendant.
We do, and
Probably solvent.
In this case, it might be. In some cases, it might not be. But I don't think that resolves the due process problem, because we go back to whether the state may delegate to a private organization, entity, its due process obligations. And I think the answer to that is clearly no. So yes, did the system break down because in this case we allege the holder failed to give notice? Yes. But the state has far more information than the holders do in many instances. And so when that property gets turned over to the state, and they have everything from the fact that they're tax-paying citizens, the fact that they own a residence, the fact that they have a driver's license, the fact that they have all of these touch points with the state, and the state has all this information. If they wanted to find them, it would be done. As I said, this is why we included the example of Governor Abbott. It just proves that they're making no effort. This could extend to the great irony of this is there are people who they hold in custody, in jail, and they have their property in custody, and they say they can't find them. It's like you have both of them. You have the person and the property. You can't make that connection. There's all sorts of ramifications of not exercising due process.
So let me ask you, I should know this because I've read all this, but I read it about 2 weeks ago. What notice was given by whom? Did the bank give any notice?
We've alleged the bank did not give notice.
You've alleged that.
The only notice.
Surely the bank knows better than to have this account emptied and not give notice to the account holder. So you got another solvent defendant, right?
We do have another solvent defendant. And again, that is one of 4 items of property that are alleged in the complaint, but it is a graphic example of what went wrong here. In other cases, we don't know. In all cases, we allege the holder didn't give notice. But I do want to say the state giving notice is different, right? We all get lots of junk mail and from all kinds of entities, and so it's easy to see how even notice from a private holder might not get opened and might get thrown away. But when you get an envelope from the state of Texas, you're more likely to open it. And so notice is different when it comes from the government than when it comes from an entity whose name you may not recall. And so I think that's another reason why we argue this procedural due process is the solution to all of this. It would avoid so many takings, and it would solve so many takings or shorten so many takings.
So what you say should have happened is what?
When the holders filed their statutory report saying we have this property, the state should give notice saying we will send out notice, say we are going to take this property, you have an opportunity to claim it. If it's unclaimed, the state gets to take it, the state gets to use it, the state gets to invest that money and profit off of it. They get the interest and any investment income off of it. No question about that. But they also have to give post-deprivation notice. And so if that pre-deprivation notice comes back in the mail and it's unclaimed, and that person has another touch point with the state, make the effort. That's the entire mission of the unclaimed property laws, is to reunite citizens with their property. We're asking to fulfill the mission. And that's really all we're asking for. And I think I want to make the connection back. The defendants didn't argue the rightness position, which they led off with in their brief here to this court. But it is the solution on both sides, because as this court's decision in the Adams case noted that when rightness is prudential, it's not jurisdictional in this instance. And so when you have a ripe due process claim, which plainly my clients do, they didn't get notice and still haven't received notice of where their property is, that gives whatever doubt there is on standing on a ripeness as to the takings claim. The Adams court said it doesn't make sense to divide the two up and wait for more to happen on the taking side while we litigate the due process claim. We have a ripe dispute, because after all, ripeness is there to ensure that you have a litigant who is interested and affected by the law, so that they were not adjudicating hypothetical disputes. And this is not a hypothetical dispute. This is a real dispute. This is an injury that my clients have suffered, and they're very motivated to invest the resources here to fully adjudicate this issue. So this is not that concern of a hypothetical dispute. And I think whether you approach it from the taking side, where they still have the ongoing violation, or whether you take it from the due process side of they've never received any notice, both sides make it ripe. Both sides make it an ongoing violation that brings us within the ex parte Young exception to sovereign immunity, and for that reason, the district court got it correct and should be affirmed on that issue. All right, I'll cede the rest of my time unless. Thank you, Your Honors.
May it please the court. As an initial matter, I'd just like to say that we didn't insert anything into our briefing about vis-a-vis the Lee Malone issue. We included that in our briefing out of an abundance of caution just because of the nature of the district court's order. We wanted to be sure we had covered all our bases. Counsel's main contention in his argument seemed to be that this is an ongoing violation. That's not correct. They have alleged that the state has possession of this property. They have not alleged that they have not alleged any facts tending to show that that will happen again for the reasons I discussed in my opening argument. The taking is not ongoing for a couple of reasons. As I mentioned, even assuming the taking were ongoing, Your Honors, they can't get relief for that. They can't use the power of a federal court to reach into the state's coffers to get relief for that ongoing taking, even assuming it was ongoing. Put differently, they can't get the relief that they seek for that ongoing taking. Now, counsel for the appellees said that his clients are still injured because they haven't received the property back. Frankly, the plaintiffs have nobody to blame for that but themselves. There is no statute of limitations on filing a claim with the controller's office. The controller's website says as much. There is no statute of limitations. At any moment, they can file a claim for the return of their property, and if that claim is substantiated, the controller is ready to give them the money back tomorrow. The plaintiffs have said that they have not gotten the process that they believe the process that they believe was due. As an initial matter, it's not entirely clear what post-deprivation notice would do at this point, because the plaintiffs obviously have noticed that this property allegedly is with the state's possession because they filed this lawsuit. Additionally, that alleged due process violation isn't ongoing because it's part and parcel of their takings claims. Put differently, their alleged due process violations have their result in the takings claim. So because
does the bank give notice?
The bank does give notice, Your Honor, under Property Code Section 74.1011.
So they say either we've gotten a request from the state to give us this money, so you need to get back to us, or they say we've given the state the money.
The state does not request from the holders that they give the state the property. The way it works is, of course, there's a statutory definition for what abandonment is, or when something is presumed abandoned. That's in Property Code Sections, Chapter 72. I believe Section 72.101 is that definition for the property at issue. The holders have the responsibility, after a certain amount of time has elapsed, as Your Honor mentioned earlier, to deliver and report that property to the controller. Once the controller has once that has been delivered to him, he has a ministerial duty to deposit it into the credit of the General Revenue Fund under Section 74.601. That section does not require him to make any kind of decision about the status of the property at that point. He just receives it from the holders and has a ministerial duty to deposit it to the credit of the General Revenue Fund. So up until that point, the state has not been active. As Your Honor mentioned, the holders, so in this case, the plaintiff's banks, have the obligation to deliver pre-deprivation notice to the account holder. The controller at that point can deliver a post-deprivation notice after the property has been deposited to the credit of the General Revenue Fund, but even at that point, according to the statute, is only presumed abandoned. Now, we of course understand that the plaintiffs are arguing that their property, or have alleged that their property doesn't fit the definition of presumed abandoned, but when the controller receives property that's been delivered to him under the Unclaimed Property Act, he doesn't know that. The banks have the obligation to report and deliver property, and so if the property doesn't fit that definition of presumed abandoned, that's effectively the holder's mistake and not the controller's. They can get a final decision. They can avail themselves, the plaintiffs can, that is, of the claims process on the controller's website. Now, of course, none of the things that I have said today mean that there is no way for the plaintiffs to get their money back, because there absolutely is. They can avail themselves of that claims process. As the Supreme Court mentioned in Whole Women's Health versus Jackson a couple of terms ago, a plaintiff seeking to challenge the constitutionality of a state law, which is what the plaintiffs are doing, even though counsel for the appellees just represented that they weren't seeking to challenge the breadth of the unclaimed property law. A plaintiff seeking to challenge the constitutionality of state law isn't always entitled to a federal forum in which to do so. Texas courts are well equipped and required to adjudicate federal constitutional claims that come to them. With that, I say that my time's about to run out, so if the court has no further questions, we'll ask the court to reverse the district court to the extent it denied the controller's motion to dismiss.
Thank you. Case has been submitted. We are adjourned until 9 a.m. tomorrow morning.